Welcome to Tolkien v. New Line, an overview of the recent lawsuit in plain English. Hi, I'm Theodora Michaels. I'm a volunteer staff member on the Tolkien's Middle-earth track, and I'm also an entertainment attorney. So there will be time for some questions at the end, so please hold your questions and we can get to them at the end of the talk. Okay, so I'm here today to talk about a lawsuit about a contract that might or might not affect the proposed film version of The Hobbit. The contract that New Line relied on to produce The Lord of the Rings is very long and confusing, so I'd like to kind of ease us into contract law by quoting a much shorter, simpler contract with which you may be familiar. Quote, "Thorin and Company to Burglar Bilbo, greeting. For your hospitality, our sincerest thanks, and for your offer of professional assistance, our grateful acceptance. Terms, cash on delivery, up to and not exceeding 1/14 of total profits, if any, all traveling expenses guaranteed in any event, funeral expenses to be defrayed by us or our representatives if occasion arises and the matter is not otherwise arranged for. Thinking it unnecessary to disturb your esteemed repose, we have proceeded in advance to make requisite preparations and shall await your respected person at the Green Dragon Inn by water at 11 a.m. sharp. Trusting that you will be punctual, we have the honor to remain yours deeply, Thorin and Company." And of course, at the end of The Hobbit, we see that, quote, "even a 14th share was wealth exceedingly great, greater than that of many mortal kings. And there was, of course, no question of dividing the hoard in such shares as had been planned. Old agreements cannot stand, since so many have a claim in its winning and defense." End quote. So it was all the way back in 1936 when Rayner Unwin, then age 10, first read The Hobbit and suggested that it be published by his father's firm, George Allen and Unwin. Flash forward to 1969. Rayner Unwin had succeeded his father as chairman of George Allen and Unwin, which had acquired rights in The Hobbit and The Lord of the Rings from J.R.R. Tolkien. Rayner Unwin signed a contract assigning the film rights and other rights in The Hobbit and The Lord of the Rings to United Artists. The current lawsuit has its origins in that contract. Like the one Thorin left for Bilbo, it was written after excited discussions by interesting characters who can't be blamed for failing to predict the vast treasure that would one day result, or the number of people involved in its winning. The contract Rayner Unwin signed in 1969 is much longer than the one Thorin left for Bilbo, and more detailed in its description of how profits are to be divided, but it is still inadequate as a guide. Unlike The Hobbit, we don't know how our tale will end. To continue the analogy, I think we're now somewhere around the Battle of Five Armies. Of course, now we've got armies of lawyers, and there are more than 5 parties involved. When I started preparing this talk, I had assumed that the original 1969 contracts were not publicly available. But I was very excited to see that New Line, in one of their court filings, included copies of the original contracts. Some people get excited about the new Sideshow collectible coming out. I get excited at the prospect of reading over 100 pages of decades-old contracts. I'm not sure if that makes me more or less geeky. New Line filed a request with the court stating that since the plaintiffs were referencing and relying on these contracts in their court filings, the court should take note of the specific language of those contracts. Makes sense to me. And since the contracts were filed along with that request, I got to read them too. There are 2 contracts, both dated July 8, 1969, one between United Artists and the trust's predecessor in interest, Sassoon Trustee and Executor Corporation Limited, the other between United Artists and the publishing company's predecessor in interest, George Allen and Unwin Limited. The contracts were clearly meant to work in conjunction with each other, but it's not entirely clear how. Rayner Unwin wrote in his book about the George Allen and Unwin Company that there had been, quote, "a negotiation of nearly 2 years' duration that was eventually consummated in a 50-page contract, the complexities and uncertainties of which have dogged the publishers and the author's estate ever since." End quote. He also described it as a complicated and ambiguous document. I fully agree with that assessment. And the ambiguities in this contract are on top of the omissions and ambiguities which are inevitably present in all such contracts, due to the nature of contract drafting and the uncertainties and ever-changing nature of the entertainment industry. I've been working in the entertainment industry for over 20 years, and in that time I've seen thousands of contracts written from the 1880s up to the present, and I've noticed that many of the same problems seem to crop up repeatedly. So in keeping with New Line's position that we can't understand the case until we understand the contracts, I'll list some problems that are common to almost all such contracts, and some particularly confusing elements of the contracts at issue in this case. One problem is rather obvious and plagues almost all human endeavors. No one can see the future. The film-going public and consumers in general are notoriously fickle. The amount of time and effort put into writing a contract is directly proportional to how much money the project is going to make, in the best guesstimate of the people hiring the lawyers. No one is going to spend months negotiating a highly detailed contract unless there's a very clear sense that the income will justify this extra effort. Certainly, even in 1969, there was already a clear sense that Tolkien's works were lucrative properties, but no one could have predicted the unprecedented success attained by Peter Jackson's films, or the immense effect they would have not only on the film-going public, but on diverse industries, including the home video market, software development, gaming, museum exhibits, and tourism. I'm fairly sure that none of those industries were on the negotiators' minds at the time these contracts were written. Think about all the lucrative properties that hadn't even been invented yet when these contracts were written, such as DVDs, video games, ringtones, and anything to do with the internet. Lawyers have ways to try to include things that haven't been invented yet. These particular contracts do cover contrivances or devices now known or hereafter known, invented or devised, but it is very common for questions to come up when trying to properly allocate royalties for new technologies based on the language of old contracts. There have also been changes in industry practices since these contracts were written. For example, they don't mention tax subsidies for film production, nor do they seem to anticipate that a film production company could be just one part of a huge multinational conglomerate with complex financial ties to other media outlets.